already stated, my name is Jay Coleman, and I'm an attorney here in Little Rock, Arkansas, throughout the state of Arkansas, as well as in Tennessee. I actually practice criminal law, but at one time before I did that, I did practice education law. I was a child advocate when I lived in Cincinnati, Ohio, and I worked a lot with the Cincinnati public school system, representing children who had disabilities, who have disabilities. More so representing them before manifestation determination reviews, which I will tell you guys all about as we get into the presentation. So without further ado, let's get started. I'm going to share my screen with you guys so you'll be able to see the presentation. So just 1 second. Let's see. Abby, can you let me know that you all are able to see it?
Yes, it looks good here.
All right, cool.
If anybody has any issues, just drop that in the chat. I'll be checking as the presentation goes along.
All righty. Okay, so Education 101. So the presentation, I'll be giving a surface lesson on education law, talking about what the IDEA stands for. I know you all have heard some of these acronyms before, but I'll be explaining what they are, what they mean, how they go into play as it concerns dealing with children with disabilities. So IDEA, FAPE, an IEP plan, that's probably the most popular education law term, a 504 plan, MDR, manifestation determination review, what is compensatory time, and then of course there'll be time for questions at the end. So let's just get started. Okay, so the IDEA, what it stands for is Individuals with Disabilities Education Act. It is codified, meaning it is a federal regulation. It can be found in Title 34 CFR, starting at rule number 1400, if you just wanted to go and read the rules, read the regulations for yourself. It was originated in 1975, just a little bit of history. 1975, it wasn't called the IDEA at the time, it was called Education for All Handicapped Children Act. And the purpose of it was to ensure that children with disabilities were able to receive some sort of education from the public school system, similar to what a child who does not have disabilities can receive, but on their education level. So you would look at what their capabilities are, where they are at that particular time when they're evaluated, and then be able to project what they'll be able to do, and then they created goals to meet what their fullest potential would be. So that was the purpose of it. Before the EAH, which I just explained to you all what it was unlikely that disabled children got the opportunity to go to school. So the statistics show that from 1970 and before, only 1 out of 5 disabled children was able to get an education in the public school system. So I know, like back in our parents' time, my parents, I'm 31 years old, children got sent away to homes when they were kids, and it seemed like, their parents were being mean to them. But now we know that really what it was is that they just didn't have the capabilities to care for their children on their own. The school system didn't have the capabilities to educate their children. So sending them to a special home for children with special needs was the only option to make sure that they got some level of care comparative to what they actually deserved and what they needed to get. Okay. Also, the EAH, it was renamed the IDEA in 1990 when it was reauthorized, and it's more so, at that time, it was made into what we now know the IDEA to be today. Okay, remember the purpose of the IDEA is to ensure that people ages 3 to 21 have access to an education despite their disabilities and their impairments. So from 3 to 21, special needs children are guaranteed and they are afforded the right to an education. And the IDEA makes sure that they get that education. Also, it's important to note that since 1970, since 2018, 7.5 million students with disabilities received an education that met their needs because of the IDEA. So that's a vast difference from the 1 in 5 children before 1970 with disabilities that received an education. Okay. So FAPE. FAPE can be found at Title 34, CFR 300. What it stands for is a free, appropriate public education. Like I told you guys before, children with disabilities are entitled to an education just like everyone else from ages 3 to 21 years old. And so FAPE ensures that they get that free and appropriate public education. What determines if your education is appropriate? It determines on where the child is. So I was telling you guys a few seconds ago about how the child will be evaluated, and then we'll see, okay, well, what is it that the child needs in order to learn? What can they attain, and how can we get them there? And then from when those guidelines are set, you're able to determine what's appropriate, what would get them to this end goal that we're saying from our evaluation that they're able to meet. And that determines if it's appropriate. If we're not meeting those goals, or if we're able to meet them, but we're just not meeting them, or whatever the case may be, they're not being met, then that education is no longer appropriate, and they're not getting the education that they are required to get per the federal regulations. Also, it's important to note that even children, when they're disabled, if they're suspended or expelled from school, they are still entitled to get a free, appropriate public education. So they're just them being expelled and sitting at home is not an excuse. They're still entitled to this appropriate public education. And there are schools that the district will send these children to ensure that they get that appropriate education. Okay, so just going further into FAPE, the state must ensure that FAPE is available to all children by their 3rd birthday. And that's very important. By the time the child is 3 years old, it needs to be already written down how they're going to get this appropriate public education. And the IEP or the IFSP must be in effect by their 3rd birthday. Of course, I'll go and explain to you guys what that means. What is an IEP? What's an IFSP? But right now we're talking about just their birthday. So if their birthday comes in the summertime, then it needs to be determined before the 3rd birthday, when will the IEP or the IFSP, when will they go into effect? Will they go into effect during the summer, or will they go into effect the first day of school? But it must be in writing when it goes into effect to ensure that the child is getting the education that they deserve. So I just told you all about the IFSP, so now I'll actually explain what it is. So what it is an individualized family service plan. And what that means is it not only affects the child, but it affects their entire family. School districts may draft the IFSP for children between ages 3 and 5 instead of an IEP, but the school district must get consent in writing from the parents stating that they want an IFSP rather than an IEP. And at the end, I'll tell you guys which one I think is better. But the IFSP is more so is generally written for toddlers up until 2 years old. So at that time, you may not know the depth or the magnitude of your child's disability if they have, for example, some sort of mental disability. You may know they're not speaking or their speech is very limited, but you may not know exactly how disabled they are. But if your child is blind, for example, or deaf, you know that immediately. So in those situations, an IFSP would be very valuable, and that's something that you would get when they're young, because I mean, how often do we deal with someone who's deaf or someone who's blind? Not a lot. So the plan spells out to the parents, how do I interact with my child? How do I teach my child how to talk if they're deaf? Or how do I teach my child just anything? How do I interact with this child? How do my other children interact with this child? That information will also be written in the IFSP. Your child will still be evaluated just like they would be evaluated if they had an IEP plan. But in the IFSP, it's also going to be written, the child's functionality will also be determined. So they'll determine physical functionality. How much does your child move around? Are they mobile or immobile? Are they active or inactive? Cognitive functionality. How does your child think? Like, for example, your child may be blind, but their mind is sharp. So that'll be written into the plan. Communication. How does your child communicate? Are they able to communicate? I mean, communication is verbal and nonverbal. So how, if they aren't verbal, then how do they non-verbally communicate? That'll be very important, and it'll be included in the plan. Also, there's social and emotional communication and their functionality. How do they function when they're 0 to 2 years old? They don't have many friends, but they may have siblings or cousins or whoever. How do they communicate with these people? Are they able to communicate? And if not, what can we do in order to make sure that they're able to communicate by the time they go to school age, if their disability would allow them to do so? And also adaptivity. Are they able to adapt to other environments? Do they have social anxiety, which will also go into social functionality? So adaptivity can kind of run into all the other areas, but that will also be evaluated and put into the plan so that we'll know where they are now, but also how I've been telling you guys, how will we get them? Will they be able to go further? And how will we get them there? The IFSP, it also will include information on the family's resources. So speech therapy, would the family be able to afford that? If not, is there some kind of remedy, or can we send them somewhere that gives free services? What are the family's priorities? What does the family see for this child? Does the family, what are the family's goals for the child? What are their priorities for the child? Not so much the priorities for the family itself, even though that could be important, but mainly what are the family's priorities as it concerns the care and the upkeep and the raising of this child. And also other concerns that the family has pertaining to the child's development, whatever they may be. That will also be put into the plan, and a projection will be created as to how we'll meet certain goals as it pertains to the child's development. The purpose of the IFSP, if I haven't said it already, is intervention services. So we're trying to catch the disability in the, we see it now. We don't want to wait till they're 5 years old if we're able to do something when they're 1 year old. So let's go ahead and start trying to get the plan in place, see what works and what doesn't. So by the time the child goes to school, we've tried a few things. We know plan A didn't work, but plan B does. So when they go to school, it could be more seamless. Also, we'll know what specialists we need to put in place. So the child needs, like I said, a speech pathologist. So we already have one. The child's already working with someone. So when they go to school, they may be at a level that they would not have been had we waited into school. We just said where they're disabled. We're just going to wait till they go to school, and the school will figure it out. That's a disservice to the child if it's something that you actually know about, you notice, and you're able to start getting a handle on it. Now, I was going to go on and tell you what did I think will be different, because in the beginning, I told you guys that if the child is between the ages 3 and 5, the school can decide whether they want to give an IEP, whether it can be decided whether or not an IEP or an IFSP is the parents' decisions, not the school, excuse me. But I believe if they're that age 3 to 5, an IEP would be better because they're already in school. The services plan, to me, it's important when the child is just at home or maybe going to daycare or something like that. But an IEP would have all the information that the IFSP would have. The IEP would say that the child needs a pathologist or needs to go to a specialist because they're deaf or whatever the case may be. That will already be in the IEP plan. Plus other programs will be mentioned in the IEP plan as well to explain, how they're going to learn, how we're going to help with them actually attaining their education. So the IEP to me is a little bit more inclusive. So if they're between 3 and 5, I would say just go on and evaluate the child for an IEP. Do not get an IFSP, because by the time they're 3, the family knows how to, or should know how to interact with the child. But if they do not, those kind of provisions can be written into the IEP as well. Okay. So we've been saying IEP 1,000 times, so let me tell you guys what that is. You can find it in the federal regulations, Title 34, starting at 300.320 and after. It will explain everything that I'm going to explain plus some. So IEP stands for Individualized Education Program. It'll be constructed either through your child's school, or it'll be constructed through the school district. It just depends on how big the school district is. So for example, Memphis City Schools, the school will do it because the school district is so large that the Board of Education can't write IEP plans for everybody. But if it's a smaller district, then the school district would construct the IEP plan. But the team will look the same, but we'll get to all of that as we continue to go. But in order for the IEP to be valid, this is very important. This is what the law states, that needs to be written into the IEP in order for it to be a valid plan. There must be a statement of the child's current academic level of achievement and performance. So that means, how's the child doing right now? Where are we? What is the foundation? What does the child have? What do they know? So then we can know what they don't have and how we need to get it. A statement of the child's annual goals. So that's where the parents will come in as well as the teachers. What do we want this child to do? Where do we want this child to be in May? And so that will be put into the plan. A description of the child's progress towards meeting the goals. So that means, how will the child be measured? How are we going to know that the child is meeting the goals that we've set for them? How will we know that? And then when are we going to meet? So you can meet maybe once a semester, but generally that's for older children. Children who are smaller, especially when the IEP is new, we might want to meet once a quarter when the grades come out. So that may be maybe once every 6 or once every 9 weeks, just to see if the IEP is working. We don't necessarily want to say after 2 weeks, oh, it's not working, because we really haven't given it enough chance to work. I'd say once a quarter is good, but if your child has had this plan for a month, or your client, if you're an attorney, has had this plan for a month and nothing's changed at all, then maybe you want to call a meeting and have a reevaluation. All right. Number 4, there must be a statement of the aids and services used in order for your child to get these services. So in order for your child to meet these goals, the child must have aids and services. We need to know what those aids and services are. And that pretty much goes back to what I was telling you guys about the IFSP, the IEP, including pretty much all the information that the IFSP would. This number 4 supports that. So if your child needs a pathologist or whatever, that aid and service will be put into the IEP. It must be put into the IEP per the federal regulations. There also must be an explanation of when the child will not be with non-disabled children. And that goes into the next sub point, which is LRE, the least restrictive environment. So even though your child is disabled, they do not have to be just confined to a room with disabled children all day if they are able to function with non-disabled children. The IEP, the goal of it is to make sure that your child is in the least restrictive environment. A least restrictive environment will be a traditional classroom. So how often can your child go to music or the elective classes with children who don't have any disabilities? If they're able to do so, they just have to go to their core classes with other children who are on their level as far as the disability is concerned, that will be considered keeping them in a least restrictive environment, because they are with non-traditional children sometimes, and then they're with children who have disabilities as well sometimes, in order to get a well-rounded education. Also, we need to know, when do these services begin? A date needs to be put on there pretty much. Are we saying that the services begin next month? Are we saying they begin today? We need to know. So that needs to be on the IEP. Also, I just feel like I should harp on least restrictive environment, because like I said, that's very important. We don't want to stunt your client or your child's growth by having them with children who have disabilities all day, when they can actually function and thrive in certain classes or in certain areas with people who do not have disabilities. So that's very important. You do not want to let the school district just throw your child into a situation when they can thrive in some aspects of their education in a more traditional setting. Okay, so how do we get in the IEP? Very important. You need to put your request in writing. Do not think that a verbal request is enough. And the reason why that's important is because if you're just going to give a verbal request and they don't do anything, what paper trail have you created later on if you want to appeal a decision, or if you want to go to the board, or if you want to file a case? you don't even have any proof of you asked for an IEP. All they have to say is we didn't get a request, and that's because you didn't put it in writing. You need to explain that your child is struggling or your client is struggling in whatever class or whatever aspect, and you need to make sure that there's a date on it, on your request. Give your request to your child's principal. Now, there are some school districts that'll tell you, that you could give it to your child's teacher, you could give it to your child's school counselor, but the federal regulations say to give it to your child's principal. So to make sure that you have all of your I's dotted and your T's crossed, that's what you need to do. Give the request to your child's principal. Then the IEP team will look at your child's history and determine whether they believe your child will benefit from an IEP. So they'll look at your child's grade level. They'll also look at your child's behavior to determine, could it be that this child is acting out not because they just don't want to listen to the teacher, but could it be because they don't understand? All of those things are going to be evaluated and used to determine whether or not your child needs an IEP or a 504 plan, which I'll talk about later. But the evaluation process is the same. If they say no, if the school says no, they're not going to evaluate your child, then you are entitled to an independent education evaluation. You'll go to the school district, and you request one. It's going to be free to you. And what that is, it's pretty much like an appeal. You're saying, well, the school said that my child is not going to be evaluated for an IEP because they don't need one. These are the facts. And I want you to look at them and determine whether you think my child should get an IEP. And like I said, it's free to you. It's called an independent education evaluation, also called an IEE. If they say no, then you can ask for another appeal, but you'll have to pay for it. If the team believes your child could need an IEP, then your child will be evaluated for one free of charge to you. So you gave your request to the principal. The manifestation team, they came together and they decided, yes, this child could benefit from an IEP. Then your child will actually have to be evaluated. And the school has 60 days, the district has 60 calendar days from the date that they decide to evaluate your child to evaluate them. So calendar days means weekends count. And also, the evaluation, like I told you, is free and it must be done within 60 days. You'll get a letter in the mail, or I'm sure they're more than likely send it through the mail rather than send it home with your child. And it'll say on whatever date they decide that your child should be evaluated, and the 60 days start from the date that's on the letter. So after your child is evaluated, within 60 days of you getting your letter saying that your child should be, then the IEP will be drafted. So the IEP team will get together and they'll actually write the IEP, which will say, everything that I said that it needs to include in the previous slide. The team has 30 days to write the IEP from the date that the evaluation is finished. So even if the evaluation is complete before the 60 days, they still have 30 days from whatever date the evaluation was completed, showing that your child or your client, they need an IEP. 30 days from that date, it must be finished. Okay, so who is on the IEP team? The most important people on the IEP team are the parents of the child. Of course, the parent knows their child the best, so they would need to be involved in this situation. However, it's important to note, parents, that you're also working with professionals, and that doesn't mean to take what the professional is saying and just run with it if you don't agree with it, but you want to balance giving your observations of your child along with what people who work with disabled children every day, what do they see? So you want to be involved, but also give them a chance to do what they need to do, and then meet in the middle. And then if you see that the plan is not working, once you've given it a chance, then you come back and say, well, this isn't working. So the parents will be there, a traditional learning teacher. Now the law says a normal teacher, but I kind of thought that would be offensive to people because just because you have a disability doesn't mean that you're not normal. So a traditional learning teacher will be there. A special education teacher, more than likely who would be one of your child's teachers once the plan is drafted. A representative of the public agency, the school district, But this representative has to be a person that's qualified to oversee the learning of the student. So someone who's able to check the plan, look at your child's progress while they're in school and compare it and see, is this plan working or is it not? That person is going to be a part of the IEP team as well. A person who can interpret the results of the evaluation and know how the results would affect the child's learning moving forward. So the evaluation will contain a lot of like medical terms and specifics that someone who does not work in that field is not going to understand. So it's going to be someone who's there and able to put the evaluation in layman's terms and explain what does this mean and what do we need to do. Also, the parents can decide to have anyone else who's familiar with the child a part of the IEP team. So this could be, maybe if it's a little kid, maybe the babysitter who babysat up to school age, or someone who just interacts regularly with the child and would know what the child could benefit from and has some insight as to what the child's needs are. That person is going to be a part of the team as well. Also, the child when appropriate. There may be times when it's not appropriate for the child to be there. Like if the child's not verbal, there might not be much, there's not going to be anything for the child to add. However, blindness is one of the qualifying disabilities. And so a blind child may be able to offer some information and some insight as to what their needs are. And so they'll be a part of the IEP team as well. Okay. Parental participation. I have dedicated a whole slide to it because that's just how important it is. It is extremely important to the point where once the IEP or the 504 plan are written, if the parent does not come to the meetings, a lot of times the meetings cannot be had because the parent has to be there. We need the insight of the parent. We need to know from your view, is this plan working? There can't, like I said, there can be no reviews of how the plan is affecting your child's learning without documented attempts of the IEP team reaching out to you and there's no response. So they have to send you letters giving you notice. They have to call you, leave you messages, give you, if they can text you, they have to text you. The federal rules state that they can come to your job and ask you, are you going to be available for this meeting? So it may seem like they're annoying you, but they're just really covering themselves because that's how important it is that the parent is there. So these records must include visits to your home or job, which I just told you all about, as well as an accounting of how many letters and phone calls went out. So they're going to say, we called you 5 times and you didn't come to the meeting. So it's pretty much, they had to decide for your child because you didn't come or you didn't say why you couldn't come. And so that's to cover themselves as to why you won't be able to complain about decisions that were made later because they tried to reach out to you. You didn't say that you couldn't come, you just didn't say anything. All right. Now, before all meetings, you must receive notice. And your notice must tell the time, the place, and the purpose of the meeting. The notice must also be in writing, like I told you guys. Also, if your child is 16 or older, the notice must also discuss post-education plans. So because, especially depending on what the disability was, even though if they're 16 or older, it has to be there, but depending on the disability, that could be more important than in other situations. Like, it's depending if they have like a mental disability, a learning disability, we're going to need a little bit more time to figure out what is their graduation goal going to be and how are we going to get there. So we can't just wait until they're technically in the 12th grade to decide what we're going to do upon graduation, if they're going to graduate at 18, because sometimes children with learning disabilities are in the school system until they're 20 or 21 years old. But it doesn't matter if they're going to be 18 or 21. At 16, we need to start talking about it. That doesn't necessarily mean that's all we're going to talk about in the meeting, but it's definitely something that we need to talk about, and we need to meet with each other ever so often to make sure that we're getting closer to those goals, because you don't want the child to graduate and not have any direction, no purpose. We don't really know what's going to happen. They're just out here, We want to make sure that we have some sort of plan in place. And if we do not, the free and appropriate public education that your child was guaranteed, they didn't get it, because at the end of the education, they don't have any direction. So that's why 16 or older, we also need to start talking about post-education plans. Okay, one of the most important things to know about the IEP eligibility is, are you eligible? So there are 13 disabilities that one may have that will qualify them for an IEP. And the next slide will list all 13. Just because you have a disability does not mean that you'll get an IEP. So for example, if you're hearing impaired, and it may be considered severe, but once you turn your earpiece on, the hearing aid, excuse me, once you turn your hearing aid on, you're able to hear just like someone who's not hearing impaired. In that case, you more than likely won't get an IEP. And the reason is because you're able to function as a traditional student once you use the help that once you use the supports that you have. Your disability must impede on your ability to learn, which goes back to the example I just gave. You are hearing impaired, but once you turn on your hearing aid, you're able to hear as though you were not. So your learning is not impeded on your hearing loss because you're able to hear once you have your aid. Okay, so these are the 13 qualifying disabilities. And they are autism, deaf/blindness, deafness, and emotional disturbance, orthopedic impairment, other health impairments, specific learning disabilities, speech or language impairment, a traumatic brain injury, hearing impairment. You might have an intellectual disability, a visual impairment, which includes blindness, but not necessarily just being blind. Or you may have multiple other disabilities that are on this list that together will impede on your child's being able to learn, and so they will qualify for an IEP. All right. Okay, so we'll go to something that's a little bit easier, 504 plan. So Section 504 of the Rehabilitation Act, and what it pretty much says is your child may not have one of the 13 qualifying disabilities that we just went over, but they still need a little bit extra help as it concerns learning. So to me, I look at the 504 plan almost like a tutor. It's not a tutor, but I look at it like that, like a little extra push almost. So for example, the class may have an hour to take a test, but maybe your child has anxiety, so they need an hour and 20 minutes. The 504 plan will have that written in, that Jay Coleman needs extra time taking his test. So you need to make sure that he's given 20 minutes to take the test. And once his test is completed, he's given a note to go to the next class and he's not marked late. That'll be an example of something that you'll need a 504 plan for. And like I said, your child may not have one of the 13 listed disabilities, but they may still experience difficulties learning. I mean, an example will be someone with an overactive bladder. I did have a client like that before. There's nothing cognitively wrong, but if you have to go to the restroom multiple times a day, you're obviously going to miss some instruction. So there's going to be a gap as far as your learning. So under the 504 plan, you may have a note taker, someone that this person, their job is to take notes, and it could be it could be like an adult, or it could be a student. They do use students sometimes. So as a student is taking their notes, at the end of class, someone will make a copy of that student's notes and give them to your child, because obviously, they're running back and forth to the restroom. They need someone to be there to be able to fill in those gaps that they missed because they're going to the restroom. Now, the evaluation for a 504 plan is the same as the evaluation for an IEP. It starts off the same. So your child's evaluated and they may decide your child does not have one of these 13 qualifying disabilities, but from what we've seen in our evaluation, they could qualify for a 504 plan. And so that's what we're going to draft up. Now, a parent could go to the school and say, well, I want my child to get a 504 plan. But that is not what you should do. Always ask for an IEP plan and let the school tell you that your child does not qualify for an IEP, but instead qualifies for a 504 plan. I think sometimes parents get embarrassed about their child needing any kind of extra supports in school, which a lot of the time, especially if they're executed properly, people aren't really going to notice, but it doesn't matter. because the most important part should be your child learning, not really you caring about, what people will say about your child having one of these plans. But so because of that, a lot of parents say, well, I want my child to have a 504 plan. That's not too restrictive. But however, I would suggest that you request an IEP because it has the most protections for your child. Because the most resources are going to be given to your child because it's projected that your child needs those resources. And that's why most children with IEP plans need a lot of resources. Under the 504 plan, they still have protections, but it's almost like, you have a little bit of extra, but the child is still kind of an independent learner. They just have something extra to help them out a little bit. But like I said, it's best to request an IEP and let the school decide that your child just gets a 504 plan. Don't you make that decision for the child. So now we're going to talk about manifestation determination hearings or manifestation determination reviews. They're called the same thing, but the acronym is just an MDR. So students, before I go into the slide, I want to say that it is very important if your child has an MDR, that if you can, you have legal counsel there. Legal counsel is very important at this stage. Important the whole time, but very important at this stage. And the reason is before the hearing, the legal counsel will look at what the accusations are. What are they saying that your child did? So let me at least explain that. A manifestation determination hearing determines whether or not your child gets suspended or expelled based on some activity that they've committed. Okay, so the attorney is going to look at the facts. They're going to look at your child's disability, and they're going to be able to map out, is it reasonable to believe that your child committed this act because of their disability or not? Is there a correlation between your child's actions and their disability? They'll do research to determine whether research states that a child that has this particular disability acts in this way. So, and then you also have that extra support, because sometimes you can feel that people are using legal jargon or talking over your head. But if your attorney is there, then you have somebody who understands what's going on. And if they are struggling with understanding, they are going to be able to pick it up quicker than a lay person, meaning someone who doesn't have a law degree or is not an attorney. So students who have an IEP or a 504 plan are required to have an MDR if they're going to be suspended from school for more than 10 days in a school year, or if the suspension will put them over the 10-day mark. So if they're going to be suspended for fighting, for example, for 14 days, they automatically are going to have an MDR first. Or if they've been suspended 7 days this year, but this next suspension is going to be for 5 days, then they have to have an MDR before they're suspended, because the 5 days is going to take them over the 10-day mark. The purpose of the MDR is to determine whether the act they committed was caused by or had a direct substantial relationship to the disability, or if the act took place because the school is not implementing the IEP or the 504 plan. So let me break that down really quickly. The first part, caused by or had a direct or substantial relationship to the disability, meaning did the child act this way because of their disability, or did the child act this way just because free will? Or did the child act this way because they're frustrated, because they're not learning, because the school is not implementing the IEP or the 504 plan, which I have had a case where that happened before. Sometimes we have to remember too with children that it can be frustrating to sit somewhere every day and not understand what's going on. Now, as an adult, we just, we can text on our phones or kind of tune you out a little bit, but children don't have the same, they don't have the same capabilities. So they're just sitting there. So their way of expressing what I don't understand is by acting out. So it could be that the child is acting out because they don't understand what's going on, because the school is not implementing the plan that's been put in place. Now, if either one of these apply, the two that we just went over, your child's actions were a manifestation of their disability, meaning your child acted this way because of their disability, and because of that, they will not be suspended or expelled. Now, if it's found that your child acted like this because of their free will, the suspension or the expulsion will stand. But remember that they're still entitled to the free and appropriate public education, even if they are suspended or expelled, but they will be. The meeting must take place within 10 days of the school deciding to suspend your child. So when they decide, well, your child needs to be suspended, within 10 days, they need to have that meeting. Parents must be given written notice and allowed to be present to the meeting. And like I told you guys before, it's very important to have legal counsel at the meetings if possible. Also, if you do not agree with the findings, you may file a complaint. Now, what you'll do is you'll file a complaint with your school's district. So here, the Little Rock Public School District, and in your complaint, which needs to be in writing, you'll give the details of the incident. So what happened? You'll give the details of the disability, and you'll give why do you believe the child committed the act in question. So those are the 3 things that you'll need to include when appealing to the school district. I was going to give a few examples of MDR, but it looks like our time is running, so I'll give one. But I had several while I was in Cincinnati, but one I remember in particular was one where the teachers were not implementing the IEP or the 504 plan. I was going to the school. I was going felt like once every 2 weeks or so because they were trying to suspend my student. But when we actually sat down and talked about everything with the teacher, because the teacher needed to be there too, but the first meeting she wasn't there. But the second meeting she was not following the terms of the IEP at all. And because of that, the child was of course getting frustrated because they weren't understanding what was going on around them. So they were acting out. So as a result, my student was not suspended. But it just shows how important that is because they were trying to suspend them for a week. So that would have been a week of education gone, all because of the teacher. So it's very important to have legal counsel at your meetings. Very important parents to stay involved with what's going on with your student as well. All right, so compensatory time. This is really our last slide. So even during the pandemic, we got monkeypox going on. We have COVID. So children are in and out of school. But even during these pandemic times, disabled children are still owed an education similar to the one that they received while in the school building. And I say similar because, of course, learning from home, you're not going to have everything that your child would have had they been at school, but you will have most things. So, for example, your child may have gone 3 times a week to see the speech therapist for an hour. Of course, you may not have everything that the speech therapist has in her office or his office, but she can still call the house for an hour for your one-on-one session. But let's say during the pandemic, she only called once a week for an hour. So that will mean that your child was shorted 2 hours of compensatory time because no one was there to educate them. The speech pathologist did not help them with their speech for 2 hours per week. So in order to determine how much compensatory time you're owed, you would say, well, okay, we were at home for the pandemic for 20 weeks and my child did not receive services but 1 hour a week. So 2 hours a week they were missing. So that's what 2 hours times 20, that's 40 hours of compensatory time my child is owed. So then you get with the school district, parents or an attorney, get with the school district and explain, look, I made a record of everything that was going on with my child and all the services my child was receiving during this time period. My child wasn't receiving his 3 hours or her 3 hours of learning. So my child is now owed 40 hours. How are we going to get my child's 40 hours back? And under the federal regulations, the district has to work with the school and with the parent and the student to determine how are they going to reimburse the 40 hours while still giving your child the 3 hours that they're getting per week now that they're back in school. So it's very important to not let school districts get away with not giving your child the compensatory hours that they're owed, because there are a lot of children who are owed compensatory hours even now from when we were at home in late 2020 and 2021, and your child is still owed that time. All right. Let me make sure. Yeah, that's it. All right, so these are my citations. Abby's going to be putting this presentation online. It's a Prezi, so we could print it out, but she's going to just post the link and it's available to the public, so you'll be able to watch it whenever, just to refer if you would like to. But that's all that I have.
All right, thank you, Jay. I'm going to read out some questions. so that we can answers to these. And someone did bring up the point that 504 plans are actually, they stem from a different federal law, the Rehabilitation Act.
Right.
Okay.
And I think I put that in the plan, but yeah, that is true. Yes, I put that. It came from the Rehab Act of 1973, I believe.
All righty. So here's one. If the requester for an IEP is made over the summer school break or at the end of the school year, do the 30-60-day response requirement apply? Are there any exceptions for when the school staff and administrations are out on school holidays? They had this come up with a client once.
From my knowledge, the 60 days would still apply. Now, I would want to get that in writing to an explanation as to why the 60 days would not apply. So if one of my clients had that issue, I would say, well, we're requesting this time. If they came back and said the 60 days do not apply because we're on vacation, they said that they couldn't meet the 60-day deadline. I would ask why not, because the regulations do not imply that if under summer vacation, the 60 days don't apply. And the reason why I say that is because even when I was telling you guys earlier about the family structure plan going into effect and making sure that FAPE takes place even if the child's birthday is during the summer vacation, those regulations, they still have to be followed. The summer vacation does not stop your child being evaluated. The summer vacation does not stop the day requirements, because the IEP or the IFSP still have to be put in effect and available by your child's third birthday, whether it's in the summer or not. So that being stated, I would say that the 60 days don't apply. I mean, they do still apply even in the summer. There's nothing in the rules that I've read or any of the experiences that I've had that have showed that they don't apply because of summer vacation, especially because generally these people who do the evaluation are in the office in some shape or form, especially at the district level. If you're in a smaller district where the school district does the evaluation, those people are generally still at work in some fashion throughout the summer. And so they'll be able to come in and evaluate your child. So my answer, Abby, is yes. The 60-day requirements will still apply even during the summer vacation.
Sorry.
Oh, it's okay.
I got kicked off. All right, so.
But I did answer to say that yes, they apply. Okay.
So some question, and they are referring to the slide that had the different members of the IEP team for that meeting. And they wanted to know, you might have to refer to the slide. They wanted to know if this person can represent multiple roles. And specifically, they were asking about the ones that you have listed as number 3, 4, and 5.
So the special education, are you all able to see it?
Yes.
Okay. The special education teacher, the representative of the public agency, and the person that can interpret the results. If they're able to represent all of those different roles, then there's no rule that says that they cannot. I would prefer for it to be more than one person, just because the more eyes, the better. But if the criteria that the regulations spell out, if they are met through one person, then there's nothing that says that they cannot be represented by the same person.
Great. Another question that someone had, and they were referring to when you were discussing what happens when a school, I think basically the question was if they're refusing to initiate an evaluation for a student, what happens then? So
then that's when you will go to the school district and ask for, let me actually go to the slide, let's see. See, I think that was in the FAPE area. But what you would do is you would go to the school and to the school district and ask for an IEE. And what that is that's pretty much a second look at determining whether or not your child qualifies to be evaluated. But you can go to the district and pretty much appeal that by requesting an IEE. I'm trying to find that slide where I talk about that.
Well, if you'd like, you can try to find that after the presentation.
Here it is.
And then I can, okay.
And you would, if they say no, if you ask the school district or your school to evaluate your child, you say no, you'll go to the school district and request an independent education evaluation. And like I told you guys, it's free. So there's no harm in asking for it. As a matter of fact, I would encourage you to ask for it if they refuse to deny your child. It doesn't matter the reason. You still are entitled to this free evaluation. So ask for that.
All right. So someone was asking, for conducting ARDs without the parent, is this legal if you have made all the attempts necessary to reach the parent?
What's that, an MDR?
The ARDs, I think they're referring to I forgot what it stands for, but the review.
The review of the plan.
Mm-hmm.
If they've exhausted all of their options as far as reaching out to you, then yes, they can review it without you, but they must have in writing, they must be able to show, if you decide later to dispute it, that, well, we called Jay Coleman's mom on this date, and this date, and she didn't show up. We sent her a letter on this time, because they have to have notices in writing. So they must also show that they, wrote my mother a letter, several letters explaining, okay, well, this evaluation is coming up in a couple of weeks. We're going to talk about this. So they can have the evaluation without you if they've reached out to you several times, but they must also be able to prove that they did that.
Someone question about consent from parents, and I answered the question and said I think once required, but I was going to check with you.
What's that again? Because it was going in and out.
Oh, I'm sorry. Someone had asked not both parents had to consent.
No.
Okay, here's another question for you that I came up with. Are only parents and legal guardians able to initiate the process outside of school administrators that can, or can it be someone like a grandparent or someone who's the person taking care of the child, even if they're not their legal guardian?
Right. If the child, say for example, the child may live with a grandmother and may not, but the grandmother is not the legal guardian, the grandmother can still ask for the report. And sometimes the school will go ahead and do the report, but now there may become a situation where they'll say, well, we need to contact whoever the child's mother or legal guardian are, and at least try to contact them. Now, if they can't contact them for whatever reason, they may be estranged or whatnot, then the grandmother's request will be enough. But generally, they will ask to at least try to contact who this person's legal parent or guardian are first. But someone who's not that guardian can request the child to be evaluated.
Okay. And another question here: how does this relate to children potentially eligible for Social Security disability, and how do these things interlap?
Now, it'll actually be a stronger case for a child to get an IEP if they get disability supplemental income for a child, more than likely, because obviously for them to get that, they have a disability. So that will further support the request for an IEP plan. I don't know if that answers your question or not.
It does. It does. And someone else had a question. I think we probably covered this. They were asking if a foster parent can request an IEP, and that person, this is not a question, but a comment from Tabitha Lee is, thank you, Mr. Coleman. Excellent presentation.
Oh, thank you.
Is there a special plan for military children that can be used across state lines?
Well, the plan, I wouldn't say a special plan, but the plan is transferable. So the children will, the parent will receive a copy of the plan. So if the child does move, then you could take that plan to the new school and say that a plan has already been put in place. Now, the thing is that there may have to be some changes depending on maybe what your old school district's capabilities are in comparison to what your new school capabilities are, but they'll still have that template from what you were using in your previous district.
Okay. A question here: if the district conducts a comprehensive psychoeducational evaluation and the parent does not agree with the results and requests an independent evaluation, does the school have to pay for that? And I think you said before that the school is required to pay for it.
If we don't agree with the results, they will pay, the district pays for the first one. Now, if you don't agree with those results, then you have to pay.
Okay. Sandra says, thank you both for a very informative program.
Oh,
thank you, Sandra. All right, so we've hit 12:59. We'll give it a minute here to see if any more questions pop up.
All right. And also, I put my email up, so if anyone has any questions, then you all can always email me and ask.
We also had some good comments from the crowd too.
Oh man, I had to go back and read them.
People were very engaged, which is understandable because this is a very important topic.
Yeah, I'm glad to hear that.
Okay, it looks like we don't have any more questions.
All right.
All righty, so before you, just a reminder for the attorneys that are on here, the CLE attendance forms are going to go out probably about an hour. A chance to review the attendance report and verify that everybody attended before I send it out. And with that, I'm going to send the presentation. All Jay's given me to do so. Typically, I send a PDF. I don't think there was a way to do that with these presentations.
I couldn't figure it out. I'm sure there is, but technology is not really my thing. So
we made it through the Zoom.
Right.
Okay. All right, so if there are no more questions, then we're just going to go ahead and call it